is usually acting first without either meeting as a board or meeting with their professionals, their managing agent, their attorney. So often, the issues that come up in the buildings in which you live are so emotional and so personal that you just react. And to be honest, and I know this sounds like a very self-serving statement, you really need to get the facts before you act and probably call your managing agent or your attorney first.
I find that a lot of boards just sign proposals of vendors and contractors when they are entering into agreements, as opposed to contacting their attorney, making sure that they have a proper contract, which includes things such as indemnification provisions and insurance provisions, warranties, etc. Unfortunately, the boards that wind up just signing the proposals and not really reading them carefully or thinking that they need an attorney to deal with them usually wind up coming to us when there's a problem. And that's really when you need the contract the most, and you need to have a contract that has the proper protections for you. So it's really, really important that you spend the money that it takes to draft the contract, because I find that it's far cheaper to have an attorney draft the contract and put the proper protections in for the boards than it is for the litigation that comes after when you have the dispute with the contractor, which invariably happens. Even if you only have that dispute occur one out of every 50 contracts, you'll find that the cost to deal with that dispute will, in some instances, far exceed the cost that you would have paid to draft those 50 contracts.
I find the most common mistake that boards make is not instituting systems, policies, and practices into place before something comes up. So, for example, when an issue comes up, whether to make an accommodation for a disability or to allow pets or something like that, or to approve a subletting, the boards are doing these things on an ad hoc basis, and it would be better for them to adopt policies which are protected then by the business judgment rule once they adopt them.